Dr. and Mrs. Fay wanted to go on the holiday of a lifetime to Greece and the Mediterranean. One of their relatives was a travel agent, and so they asked her about options, and on her recommendation, they joined a group she was leading for a cruise on board the vessel Stella Oceanis, which was operated by Oceanic Sun Line in Greece. They paid their fares in full, and the Australian agent for Sunline issued what was called an exchange order. They issued that order to the travel agent, who then met with the Fays in Athens. They provided the exchange orders to Oceanic, who then issued the tickets. The tickets included a range of clauses, including one which required that any legal action which might arise from the cruise would have to be brought in the Greek courts, and another which limited maximum liability to $5,000. They boarded the vessel, and on the cruise one of the activities was trap shooting. The shotgun being used by Mr. Fay exploded and he was injured. He sued in New South Wales, but the company objected on the basis that he should have sued in Greece for a maximum of $5,000. The High Court had to consider whether the ticket clauses were actually part of the contract, which in turn meant considering where and when the contract was actually formed. Each of the judges of the High Court agreed that the contract was formed when the Fays paid the full price for their cruise and when they were issued the exchange order. When the ticket was issued in Greece, this was merely part of the process of executing the contract. It wasn't the commencement of a new contract. Justice Brennan said, "It can hardly have been the party's intention, at the time when the passenger pays his fare, that the ticket to be given him on boarding should be a mere offer of carriage. Much less could it have been their intention that the offer might contain exemption clauses which were unknown to the passenger when the original contract was made. It was too late after the original contract was made to add conditions which were not incorporated in it. From this case, we confirm the principle that once a contract has been formed, neither party may unilaterally add new terms to the contract."